This was a case that we got referred at the end of 2020. It was an accident that had happened in August of 2020. And if you want to just understand what this case is all about, I have a visual that pretty much just tells the story. So I will share my screen with you all now. And Miss Neely is riding on her Harley Davison motorcycle when that happened. 75 years old, traveling northbound State Route 79 in San Diego. And like a bolt of lightning, a 6,000-pound tree limb on a Caltrans tree in their right of way snapped and landed on top of her. Again, she suffered horrific injuries. This visual goes through and we'll just kind of touch on it here. A horrible femur fracture. I mean, bones coming out of skin and the whole nine. Multiple surgeries, very serious concern about the need to amputate her leg, actually, and they weren't even sure if they would ever be able to save it. Spine fractures from C7 to T8. I mean, it just basically her spine essentially exploded as a result of the impact. She was hospitalized for a little over 9 weeks, then had about 2 more months in a rehab facility. Like I said, every part of her was pinned and screwed and anchored and you name it, as a result of what was obviously and what discovery kind of bore out was a very preventable incident. And so this was a case that we got. This was also, she was living in a facility and there was concern early on. I mean, she's 77 years old. She has no feeling from the spine, from her breastbone down. Folks like this, anybody who's handled spinal cord injury cases know these people are at huge risk for infection, right? They don't have feeling, so they don't know if they get a UTI. She's incontinent of bowel and bladder, and so UTIs are a very common event, and people like this can pass away very quickly. And so this was a case that this was right when the law changed about pre-death pain and suffering. That dropped at the end of 2020. In fact, it only started in 21 unless your case was preference set. And by the end of, by 12/31/20. And so needless to say, when that dropped, I think on 1st of October, we got our preference motion set as soon as we could, obviously hoping we would never need to exercise the rights under the new law. But we went down and got a preference set. And as we'll talk about some more, preference cases, they are the best of times. They are the worst of times.
And the worst at the same time.
Because we did, we did 6 months of work in 6 weeks.
Right. And that's insane considering the magnitude of the injury. And at the time, what we all know now is that it was a disputed liability case. I mean, you're trying to get Caltrans to admit liability and they're fighting you tooth and nail, and you've got to still take all those depots even though last minute they're gonna admit. So you talked briefly earlier about just this was preventable. I want you to kind of go into a little bit of that and tell us why. I mean, a tree falls out the sky. Sometimes those are just acts of God.
100%. 100%. And that was probably just from a kind of a philosophical or kind of intellectual side of things, probably one of the biggest issues and hurdles, right? Because like you, I informally focus group my cases with, my Uber driver and the dude who cuts my hair and, whoever else I can talk to that is not a lawyer. Right, just to kind of, you give them the elevator pitch and you tell them about the case, and people's first reaction is, well, how could you stop that? Right, there was no storm, right? You saw that was accurate. It was a beautiful day, right? Beautiful day, sun shining, 3 o'clock in the afternoon. Jane's just going home from her job at the Julian Pie Company. And obviously, that begs its own series of, like I said, existential angst about the universe. But we started on this case, and one of the first things you come up against, just like any governmental entity case, there's always immunities. But this one, they have the natural condition immunity. And so basically, there's about 7 published opinions in the state of California history on natural condition immunity. 6 of them go the wrong way. And what I mean by that is finding that the natural condition immunity applies. And so we started out from the jump recognizing that that was a huge obstacle, because basically the immunity, if I were to summarize it, is if a tree falls in the woods, you are out of luck. You can't sue the government over that. And there's cases that, again, are on all fours, including cases where the tree falls and it's a couple trees in and it lands in the parking lot and squishes somebody. And the courts are like, sorry, nothing we could do, which from a policy perspective, I understand, right? Because otherwise, if we're going to have land open for people to go out backcountry and hiking and biking and whatever else people do, we cannot expect the government to ensure the safety of every person on every trail, out in the woods. That said, this was not that. Again, at least was our argument, but the cases seem to suggest that it was. So the thing that I did, and this just goes to, good old fashioned picking up the phone and reaching out to colleagues who do what we do, right. Found the one case that went our way, right? And it was John Feeder and Tim Tejan up in San Francisco. And I called those dudes and I was like, so how do I get around this thing? And they gave me a theory based upon an arborist that they used, who basically established in their one case, in a case, I forget the site, but I know it's against the county of San Mateo, that it was a series of unnatural conditions. This was a young child that was horrifically injured at a campsite. They established that the campsite was in basically a man-made condition. The paving of the roads, the placement of grading. There we go. Thank you for someone just dropping that. Roe versus County of San Mateo in the chat. That case ultimately gave us a roadmap. And not for nothing, I also picked up the phone and I retained that arborist immediately. And I flew him down and I said, oh, what do you think? And immediately he said, look, the way the roadbed is, located, this is a problem, right? That's putting stress on the tree. There was a drainage culvert that didn't work. It was just a drainage culvert. It was literally a culvert to nowhere except for the base of the tree. So eventually it's going to push up against this tree, cause it to rot, cause it to decay, blah, 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 blah. All of those things, again, are our constant theme from the very beginning when we filed the case to when we responded to form interrogatories to every deposition we took, was to focus on the unnatural aspect, the man-made aspect that caused and contributed to this thing. And so that's where we focus. But if you've ever handled a governmental entity case, you know that you got to take 50 depositions to get the answer to a simple question. So
and review thousands of pages of documents, and we'll get more into that. But leading up to this, were there any settlement discussions? Why are we here?
There you go. Why
when
are
a tree falls out of the sky? Right.
Well, I will tell you this. I think if this case was against a private entity, we probably wouldn't be here. So I have to thank Caltrans for their unreasonable settlement posture. So case goes forward. When liability was still in dispute, we came out of the chute and demanded 20 million. I wanted to set the bar high. I wanted to set their expectations high, that this is not a case that they're going to settle cheap. I recognize that it's not a case you maybe get 20 million on, but again, I could always reevaluate that posture later on. But that's what we came out of the chute with. Flash forward, we work it up during litigation. They eventually serve us a 998 a couple months ago for 6.5 million. After the pummeling in both fact and expert discovery. And about 2 weeks before we were set to try the case last month, I got a phone call that they were stipulating to liability and causation. And I mean, because causation, it couldn't really be meaningfully disputed, right? Some of the extent of the harm, you could argue and squabble about damages, but obviously she didn't have these injuries before. And so that is, again, for anyone who's handled governmental entity cases knows that that is a unicorn. They don't stipulate to liability. I mean, they won't stipulate to liability in cases where I have verdicts against them, where I have found liability, right? Like they still fight me.
Exactly.
Even after a jury's found them liable. So they upped their offer to $10 million.
Which is also pretty unheard of for a governmental entity. I mean, the hurdles they have to clear in order to get authority to offer anything in that range is insane. So yes.
Yeah, so that had to cross like Gavin Newsom's desk, right? To, you know, and he's been busy, right? Like we know he's been busy doing some stuff. You know, Nick Rowley's been calling him 4 times a day, and Craig Peters and everybody else, you know, along with everything else the man does. So yeah, to get 10 million, you know, again, they don't offer me that even in cases when I've gotten that size verdict against them. So it's a rare event. But they did ultimately dangle $10 million in front of my client. And by any objective measure, that's a large pile of money, right? But what happened there was, and that's risky, right? You got to look at that, and you know, even when they stipulate, you know, you got to look at that and go, damn, this might not go our way, right? They were going to come in and argue that her meds were, you know, they were arguing a loss of life expectancy. That was going to be $3 to $5 million in future care, give her a few $1 million more, you know, and some of that could resonate. And that's the self-doubt piece, right? That's the stuff that kind of keeps you up at night when you start thinking, damn, like you don't want to be, you never want, you know, no ego amigo, right? You don't ever want your ego and your sensibility to ever get in the way. And we've all heard those stories, right? People don't talk about them very often, but we all know the stories are out there where people have turned down large piles of money and gone to verdict and done substantially worse.
Yes, and then you see them in the restroom vomiting because
100%.
they know it's over. So
it is.
No, so I mean, your client's in a position where she is confronted with a $10 million settlement, and you as her attorney have to advise her one way or another.
You do.
But tell me about that conversation. I
will. And so one of the things that I have here, and again, anyone's gonna, you know, sooner or later you may find yourself in this boat, and if you do, you have got to CYA, right? You have got to have the conversations, get the constituencies, right? Her kids, you know, her adult children were obviously involved in her life and in her care. And we needed to have some real conversations with everybody. And, you know, and like I said, this is not a lady who's rolling in money. You know, she lived in a trailer in Ramona, right? She's 77. These are real issues. And so we had some serious talks about this, about the risks. I told her, do I think I can beat 10? Probably, right? But it's probable, right? We live in a world of probability. And so I said, it's probable. I said, you know, 15, 20, at that point, it starts to get dicey, right? And so I ultimately had these conversations. She came back to us and said that 15 million was her bottom line. And I said, okay, right? And we talked through it, right? We talked through it. And I said, look, she said, we've all had greedy plaintiffs, okay? We have all represented a greedy plaintiff who has cashed an imaginary check. This was not that. This was actually someone who said, you know what? After I pay you and I pay the liens and I pay the costs, I'm gonna net about $9 million on 15. And she said, that gives me, and that's where I said, how do you come up with 15? She came back and said, I want 15. I said, all right, how did you get there? And that's what she explained. And she said, after the 9 million net to me, I can be sure that the full life care plan, every cent of it will be paid for. And I get a few $1 million for the fact that I'm stuck in this goddamn wheelchair for the rest of my life. you know, that's fair. That was a totally, and I even went to the, hey, but you know, the life care plan, there's a little, you know, we got some stuff in there. It ain't gonna, you're not gonna have to pay for it all, right? All the attendant care. What's the big matzo ball in every care plan? Attendant care, right? And so, and then the surgeries and these other things, a lot of this stuff's gonna be covered and you're not gonna have to worry about it. And she looks me straight in the eye and she's like, Brett, she's like, giant trees fall out of the sky and land on me. Like I'm not taking anything for granted.
Exactly. I want it all.
So I said, cool. So then if you do that, if you find yourself in that position, then you need to do something like this, where you explain settlement rejection and trial risk, right? We memorialize the fact that this is your bottom line, right? In light of their stipulation, I explained to her, this is, you know, that we could probably do better than 10 million. However, that means more likely than not. That means I got a 51% chance, but there's a 49% chance that it could come in at or below that, right? Or some variation of that. And then explain to her that obviously all of this depends, because it's so hard to do this in a vacuum. I knew I wasn't going to have my trial judge. I knew I was going to get sent out to some other department. Obviously, we don't know who shows up for jury duty that day. Obviously, we never know how the evidence is going to come in, right? I have had experiences too where offers like this have been made during trial. And you do the same thing, right? You get back to the office if you got to, or over the lunch break. And if you got to hand write the thing out on a friggin' legal pad and write it out and have them sign it because they're rejecting an offer that's made during trial, you do that. Because again, we all recognize that things might go different. This is why we call them trying a lawsuit, right? We're all just trying. And I made very clear that if Caltrans is unlikely to offer you $15 million short of a jury verdict, and we will have to trust this outcome to 12 honest, hardworking San Diegans. So that's how I finished it. And I said, there's nothing guaranteed in life and in law. I look forward to trying this case and doing everything in my power to make you proud. And I said, let's roll. And she signed off. She consented to proceed. And off we went.
So you already had in mind a number, and it sounds like it was in that range that they offered. How did you get to that? And when I say how, we talked about informal focus groups. Did you have a formal focus group? What was your process, your thinking, and like, how did you get to that particular number?
Right. So I will tell you that my evaluation of this case actually went down after focus groups. And I think one of the things that's important, and we'll touch on that now, is when we had focus groups, we were obviously putting them on. You know, I don't do my focus groups typically a week before trial. I'm usually a month, sometimes many months out. And this was probably a month or so before the case was initially set. And we were doing a liability, causation, damage case. And the numbers that we got there, going back to the preventableness of this thing, were huge. And that's because people saw this.
Huge. That's relative. What are we talking about?
So I had focus group jurors, when they heard the full story, about what Caltrans did and what they didn't do, and I'll talk about that in a moment, that wanted to give us $100 million. Now, there were similarly outliers who wanted to give us between 5 and 10. Right. But there were more people who were in the upper echelons of substantial 8 figures, 20, 30 and beyond. You know, and I only had, like I said, I only had 1 or 2 who wanted to give me 5 to 10. I only had 1 or 2 who wanted to give me 100 million. But the meat of the curve was a larger figure when we told the full story, because there was tremendous piss off. And jurors saw it in a very kind of punitive fashion.
Right, they were outraged.
Exactly.
Okay, and you'll be able to tell us what really set some of these folks over the edge, because that's $100 million is a whole lot of outrage.
It is a whole lot of outrage, and this was a case that did it. Right, everybody knows you can't get punitive damages against governmental entity. Unfortunately. But what I've also learned is you really have to show, in a dangerous condition case, you almost have to prove reckless conduct, right? You almost have to prove punitive conduct, because people's expectation of their government is so low that when you show them that, they kind of expect government to operate like the DMV. And so if you show them DMV, you're met with a shoulder shrug and an eye roll, right? So you got to show them something more. And that's why you got to go deep on these cases. And so the thing that was I think I mean, there's a lot, but we ain't going to cover it all because this trial was ultimately about damages. I want to talk about that, but I want to show a couple of things here. So these are what are called IMMS records. Okay. These are Caltrans maintenance records.
Oh, don't we love these? Don't we love these?
And so they tell you, supposedly this is supposed to tell you what they did, the work order, who was responsible, when they did it, what route they did it on, and what they did on a supposed date. Okay. So we asked for this stuff in discovery, and they give us hundreds of pages of this one. This is one of a multitude of these things. And I knew when I took the PMQ deposition for Caltrans on tree inspections in this area that I needed to go deep into the documents and spend a lot of time. And my eureka moment where I knew that we had them was probably back in, I think, January or so, when I was taking this deposition. And I'm reading through all this stuff, and I'm sitting at my kitchen table, and it's like 10 o'clock at night, and my kids are in bed, and I'm just going through the mind-numbing review of a decade's worth of tree inspections and everything else they did. You know, they did lateral support, they cleared the road, they cleaned a drain. You know, you're just going through and going through, but I'm focused and with an eye towards tree inspections. And all of a sudden I see one inspection that they did at the end of 2017. They're supposed to do these every year. They're supposed to go out and look for certain things that are dangerous about a tree, and in particular on this corridor. And I read it, and then I flip through about another 30, 40 pages. I read one inspection. I get to the next one. I go, wait a second. That looks awfully familiar. And I flip back and I flip forward and I go, no shit. And this is what it comes down to. These are two inspections. They're about 50 pages apart in the Caltrans production. From 12/5/17 and 2/6/19.
So 2 years apart.
2 years apart. They missed it in 2018. They were supposed to do it then. They got to it a few months later. But if you read this closely, what you realize is they didn't do it. It's a cut and paste. It's the exact same entry. They even had handwritten logs that they went in and rewrote the same thing in the handwritten log to then substantiate it, right? It was like, I don't know about you, but when you were a kid and you had to, like, over the summer, you had to show, like, you had to write all the books, you know, that you read and do like a little book report over the summer. Well, it'd be like the third week of August and you'd be like, shit, I haven't written anything. So you're pulling out a blue pen, right? And then you write another one in black pen to make it look like you've been doing it all summer. No, that's what Caltrans did here. And so I got this PMQ, you know, I got them all dialed in. Well, how do we do these annual tree inspections? Oh, it's for the safety of the motoring public. And this is an important public safety, you know, inspection. Yes. And we got to do this for blah, blah, blah. And I mean, I get him deep, right? I get him deep on all of those things. It's just the setup. And then I throw this is exhibit 9 to his deposition that I took, just cutting and pasting the two. And I said, read those two. I said, do you notice anything? They look awfully similar.
Please say you said it just like that. And you leaned.
Just like that, 100%. No, I swear to God, I got it on video. Like, I didn't bother clipping it out for today, but it's literally that good. And he goes, they look awfully similar. I go, no, they're identical. How could that be? And then just word salad. Like, it didn't matter. It didn't matter what they said. It didn't matter what the explanation was, because we had them falsifying a government safety inspection.
So that's the outrage that the focus group participants they see that and they think, oh no.
It was people, we put it up on the things, we do them all online still. And people, I mean, they're all just audibly, are you kidding me? Did that just happen?
So, I mean, you have that evidence in a focus group. because you're dealing with liability at that time. But by the time you get to trial, that's a non-issue. That's a non-issue. So you're taking a risk. What is your, thinking? Why you don't have that smoking gun anymore?
You
it
don't.
Frankly, it's a game changer. So what's the rationale?
A total game changer. And the rationale there was, like I said, we got a tougher case now. Like, they're just going to put on a competing damage case. Right. And I got nothing really to get anybody pissed off about. So then it just becomes about harm. Right. It comes just about loss. And then you are just all in and singularly focused. And obviously, there cannot be a worse, I don't think, maybe a burn injury or something, but paralysis, right? That loss of freedom of movement is one of the things that I think most profoundly impacts people when they hear about it. It invokes kind of the highest levels of empathy. And so you got that, right? But that's all you got. And so that's what you make the entire case about. And that's what we made the entire case about. But having very candid conversations with the client as to, 10 million bucks is real money, and they might go with that. So are you prepared to turn that down? Again, at 77 years young, and roll the dice, understanding that if we light this thing up for 30 or 40, you could very well buy yourself an appeal for the next couple of years.
Correct.
So, there was a lot of risk. There was a lot of, like I said, and it kept me up at night. I ain't gonna lie. But at the end of the day, once she signed off and was like, no, let's do it, then it's good. Right. Then it's like, okay, I'm all in on this. I would not have begrudged this woman if she had decided to take $10 million. I don't think anybody could. But you do what's best for them, and you got to take the biggest swing you can. And just reputationally, this is the rising tide piece to this thing. What I'm most proud of about this verdict, beyond taking care of Miss Neely, who is going to be good like forever now, is the piece that we made very clear, and I conveyed to Caltrans right after that letter came from me on the 19th of last month. And I said, listen, 15 is the bottom line. Like, if you want to offer me anything less, we'll see you at verdict. And it's from a reputational and from a rising tide perspective, when you look the defendant in the eye and you tell them that if you pitch me this ball, I am going to hit it right over that left field wall, right? And then they're like, we'll pitch it. And then you knock it and you clear it. That's good for everybody.
Yeah,
right? That's
good for
everybody.
you. It's actually really good for you. It means that, next time they know what's coming.
Yeah, but I sue them all the time, dude. I don't get any respect. This is not my first,
respect on my name.
Yeah, exactly.
I get it. So, Brett, let's talk a little bit about the motions and limines. We're in trial.
Mm-hmm.
We're getting ready, the pre-trial motions.
Yep.
Walk me through it. Let's talk about it.
So a couple of things. So one that ended up not being a motion in limine, but I want to touch on here. Obviously, I think we have a pretty California, centric crowd on this thing. So I will touch on it, but a little known codicil of the law in governmental entity cases is Government Code 985, and this will also be part of the materials that I know everyone will be able to access afterwards. But Government Code 985 says that collateral source payments from HMOs, private health insurance, disability, you name it, any collateral source payment are inadmissible in a case involving personal injury or wrongful death against a governmental entity.
Oh, which is so good.
Right. It's like the before times. Right. And in fact, if you have any question, and this is from my last trial against them, but I'll, like I said, give it to you all here. They all go, but Howell says blah, blah, blah. Hey, don't forget, it was Howell that says very clearly, our holding neither contradicts or undermines Government Code 985 or 3333.1, right, which is collateral source in a med mal case, nor alters their operation.